Cybercrime is one of the most serious offenses as of today, where millions of people were getting victimized in just a matter of seconds. We learned in criminology that crime is dynamic. It changes. It varies. And one of the innovations of crime is the cybercrime. As an example, we heard in the recent news that the Microsoft company was hacked. Imagine, a big company such Microsoft company was hacked. What damage it can inflict for small people just like us. And again, in the recent news, a young Filipino hacker to be specific, was able to hack bank accounts and bank system and was able to steal money electronically. And perhaps we can say that cybercrime must not be taken for granted. That's why today, we will learn what is cybercrime and what are the laws that the Philippines has in combating cybercrime. But first, let's take a look what is cybercrime. Cybercrime is any criminal activity that uses a computer either as an instrumentality, target, or a means for perpetrating further crimes comes within the ambit of cybercrime. A generalized definition of cybercrime may be unlawful acts wherein the computer is either a tool or a target or both. Cybercrime is a term used broadly to describe criminal activity in which computers or networks are a tool, a target, or an incidental to the commission of a crime. Any offense that can be committed by means of a computer, computer system, computer, or communication networks or networks. Any offense which has its target a computer, computer system, computer or communication network or networks. The use of computer, computer system, or communicating networks as means of hiding, storing of possible evidences. Generally speaking now, cybercrime has three major elements: computer as a tool, computer as a target, or computer as incidental to a crime. The main difference now between cybercrime and crime committed in the physical world is that cybercrime is committed with or through the use of information and communication technology. Furthermore, cybercrimes are punishable under special cybercrime laws and subject to distinct law enforcement provisions. Number 1, the capacity to store data in comparatively small space. The computer has unique characteristic of storing data in very small space. These affords to remove or derive information either through physical or virtual medium makes it much easier. Number 2, it is easy to access. The problem encountered in guarding a computer system from unauthorized access is that there is every possibility of breach not due to human error but due to the complex technology by secretly implanted logic bomb, keyloggers that can steal access codes, advanced voice recorders, retina, imagers, and etc. that can fool biometric systems and bypass firewalls can be utilized to get past many by a security system. Number 3, it is complex. We all know that computers are hard to understand. It is not easy to master. That's why the cyber criminals take advantage of these lapses, these lacunas, and penetrate into the computer system that makes it more vulnerable for crime. Number 4 is negligence. It is very closely connected with human conduct. It is therefore very probable that while protecting the computer system, there might be any negligence, which in turn provides a cybercriminal to gain access and control over the computer system. Number 5 is the loss of evidence. Loss of evidence is a very common and obvious problem of all the data are routinely destroyed, such as by using denial of system, hacking, or any penetrating data, viruses, keyloggers, or etc. that is used by the criminals. Let us now talk about the categories of cyber criminals. Number 1 is the children and adolescents between the age group of 6 to 18 years. The simple reason for this type of delinquent behavior pattern in children is seen mostly due to the inquisitiveness to know and explore the things. The other cognate reason may be to prove themselves to be outstanding amongst the other children in their group. Further, the reason may be psychological even. So basically, this type of cyber criminals, they tend to do cyber acts or illegal cyber acts because of curiosity. Because of their age, they tend to explore more about cyber or about the internet or about computer. That's why unknowingly they committing cyber acts or illegal cyber acts. Number 2, organized hackers. These kind of hackers are mostly organized together to fulfill certain objective. The reason may be to fulfill their political bias, fundamentalism, and other. This type of hackers now, they are the one who are politically inclined. So, ginagawa nila yung illegal cyber activities for the purpose of political attacks. Note, the Pakistanis are said to be one of the best quality hackers in the world. They mainly target the Indian government sites with the purpose to fulfill their political objectives. Further, the NASA as well as the Microsoft site is always under the attack by the hackers. So mostly, these organized hackers, their main goal is political. Unlike these children, yung nauna na nabanggit natin ng una, they just do illegal cyber acts because of curiosity. Then number 3, professional hackers or crackers. Their work is motivated by the color of money. This kind of hackers are mostly employed to hack the site of the rivals and get credible, reliable, and valuable information. Further, they are even employed to crack the system of employer, basically as a measure to make it safer by detecting the loopholes. If we will take a look of kinds of hacker, we can see that there is a white hacker there, not just a black hat, but there are several kinds of hacker. One of them is the white hat. Just like as mentioned here, they are the one who are employed to crack the system of the employer to measure it safer and by detecting its loophole. So, ginahire yung mga white hacker na to para tignan, i-check yung server ng mismong employer nila. So, tinatry nilang i-hack, titignan yung mga possible vulnerabilities ng site at i-strengthen yon. So, basically, these professional hackers are money motivated. Their work is motivated by the color of money. Lastly, is the discontented employees. This group includes those people who have been either, I may say, sacked by their employer or are dissatisfied with their employer to avenge they normally hack the system of their employee. This type of cyber criminals, they are the ones who take revenge against their former employer, I may say. That's the reason why they commit cybercrime, because they are not contented with either with the policy or maybe may nangyaring hindi maganda sa kanila, ginawa sila ng masama ng kumpanya. That's why they take revenge in the form of cyber activities. If we will compare the 4 of these, it has been said that the heart of cybercrime are the hackers, for they are the one who has the skills to commit it. Right now, let us learn about the 2 typologies of hackers. The first typology is about their characteristics, while the second typology is about their relationship to their computers.
The first typology comes from, number 1, the pioneers. Those who are fascinated by evolving technology and explore it without knowing exactly what they are going to find. Number 2, the scamps. Hackers with a sense of fun who intend no overt harm. Number 3, explorers. Hackers motivated by a delight in breaking into computer systems. The more geographically distant or more secure the target the greater the delight. Number 4, team players. Those who enjoy defeating software or system protection with hacking seen as sort of game for itself. The vandals. Those who cause damage for no apparent gain. And lastly, the addicts. Nerds who are literally addicted to hacking and computer technology. Number 1 is the playpen. They see computer as a toy and not as a weapon that can possibly inflict harm. Number 2, the fairyland, where cyberspace is an unreal world where wrong cannot be done. Here, they think of cyberspace as a free fair or a fairyland that they can explore. Number 3 is the land of opportunity, where there's nothing wrong with exploiting a vulnerable system. Another one is the toolbox, in which the computer is just a way to get other things done. Number 5, cookie jar, with the computer as a place to go borrow things now and gain. And lastly, the war game, where hostile feelings are vented against machines rather than people. Let us now learn the mode and manner of committing cybercrime. According to the 2001 Budapest Convention on Cybercrime, categorizes cybercrime offenses into 4. Offenses against the confidentiality, integrity, and availability of computer data and systems. Number 2, computer-related offenses. Number 3, content-related offenses. And number 4, offenses related to infringements of copyright and related rights.
As we learn about the modes and manner of committing cybercrime, if we were going to base into the Republic Act 10175 or the Cybercrime Prevention Act of 2012, it is categorized as into 4. Number 1, offenses against the confidentiality, integrity, and availability of computer data and systems. Number 2, computer-related offenses. Number 3, content-related offenses. And lastly, those other offenses not mentioned. Let us now talk about the first category in the modes and manners of committing cybercrime. That is the offenses against the confidentiality, integrity, and availability of computer data and systems. So number 1 is the illegal access. Illegal access is the access to the whole or any part of a computer without right. These includes the act of hacking, cracking, or simply the unauthorized entry of a person into a computer system without consent or knowledge of the owner of the computer or the computer system. So basically, illegal access is like trespassing. Pinapasok mo yung server, pinapasok mo yung data nang walang paalam dun sa may-ari. So from the word itself, illegal accessing. So in illegal accessing or illegal access, it has two major components. Number 1 is hacking. So hacking is the act of illegally accessing the computer system network of an individual, group, or business enterprise without the consent or approval of the owner of the system. So hacking, mostly it happened in social media accounts. So madalas, hinahack yung mga Twitter accounts, ano pa ba? Yung mga other accounts na related sa atin or personally related sa isang tao. And just like recently, just like the Microsoft, even the Microsoft, nahack sila just recently. Number 2 is the cracking. Cracking now is the higher form of hacking in which the unauthorized access culminates with the process of defeating the security system for the purpose of acquiring money or information and availing of free services. Cracking now is the higher form of hacking. So the goal of cracking is to either acquire money, information, or availing for free services. Madalas tong ginagawa sa mga applications na may bayad, just like Microsoft, ProPresenter, SketchUp, or other monetized applications. So madalas ginagawa itong cracking to either to earn money or to avail an application or a software for free. Unlike hacking, you just penetrate and acquire the password and look upon that specific data. But unlike the cracking, you have something to gain. So dito sa cracking, nag-gain ka na. Unlike sa hacking, you're just accessing. But in cracking, you gain something. Okay, that is illegal access. Number 2 is the illegal interception. From the word itself, you are intercepting data from what? From communication. But technically speaking, interception by technical means, it is listening to, monitoring, or surveillance of the content of communications to the procuring of the content of the data, either directly through access and use of the computer system, or indirectly through the use of electronic eavesdropping or tapping of devices. So, itong illegal interception, most commonly used to tap information through communicating lines. Alright? Communications of employee, whether or not business purposes or constitute non-public transmission of computer data, are also protected interception without right. For criminal liability, to attach, the illegal interception must be illegally or committed intentionally and without right. The act is justified, for example, if the intercepting, take note, if the intercepting person has the right to do so. So kung may karapatan naman yung taong nag-i-intercept ng data or ng communication data, and if he did it, if he did it unintentionally, he or she is now justified from illegal interception. Number 3 is a data interference. What is data interference? It is the intentional or reckless alteration, damaging, deletion, or deterioration of computer data, electronic document, or electronic data message without right, including the introduction or transmission of viruses. Now, the aim of this provision under Republic Act 10175 is to provide computer data and computer programs with protection similar to that enjoyed by corporeal, I may say, objects against intentional infliction or damage. So deletion and alteration of data is at stake if there is data interference. So the law included this one to protect this data. Why? Because it is considered as a valuable thing, such just like a corporeal objects in the physical world. So alteration and by means of modification of existing data is what is done in data interference. So how to do, or how a criminal, cyber criminal do data interference, I may say. That is the use of, number 1 is virus. What is now a virus? Viruses are programs that attach themselves to a computer or a file and then circulate themselves to other files and to other computer on a network. They usually affect the data on a computer either by altering or deleting it. Just like a human body, viruses tends what? To destroy our cells, or to make it a simple saying, sinisira nila yung program ng katawan natin. Just like in the cyber world, just like in a computer, viruses tends to attack the data. It's either to alter or to delete it. Next one is the worm. Unlike with the viruses, this worm doesn't need a host for them to be attached to the computer data or to the computer system. Unlike with the viruses, in virus, they need a host first for them to penetrate to the data system of the computer. But this worm doesn't need a host because they recreate themselves. Though, despite the fact that they have similar goals, that is to destroy and alter data, the way of their penetration is different. This worm, they recreate themselves. These viruses, they need the host for them to be attached to the computer data system. There are several instances of data interference such as spamming, email spoofing, data idling, password sniffing, buffer overflow. But what I mentioned a while ago, they are the most similar and most common used by the criminal or the cyber criminal. Now, the denial of service or the DOS. Let us take a look upon what is the meaning of DOS. So DOS is an act by a criminal who floods the bandwidth of the victim's network or fills his email box with spam mail, depriving him of the services he entitled to access or provide. These attacks may be launched from a single computer or from millions of computers around the world. Denial of service attacks, malicious codes. So the denial of service, basically, deny mo yung system for them to provide services. Kunwari, a website or food website, you deny them for the people, let's say, to order to that website. So you deny the service of that system. Alright? You penetrate to that system, and then you deny the service of that website. So for them, for that website not to do their function or to do their job as a website. Kung ano man yung trabaho ng website na yon, you deny their services. As mentioned, malicious code is a software or a code which modifies or destroys data, steals data, or allows unauthorized access or exploits or damages a system in a manner not intended by a user. An act by criminal who floods the bandwidth of the victim's network or fills his email with spam mail, depriving him of the services he is entitled to access or provide. These attacks may be launched from a single computer or from millions of computers around the world. Last in the system interference is the web defacement. Web defacement now is defined as an act of intruding into a server and changing without permissions all the aspect of a website which the public can see. So, from the word itself, web defacement, you are defacing the web or sinisira mo yung image ng website na yon. Just like in vandalism, you tend to ruin a wall from what a public can see, you vandalize it, and now people can see other things. Just like in web defacement, in similarities, you are changing or you are defacing the image of that website. Number 5 in category 1, the misuse of devices. The use of production, sale, procurement, importation, distribution, or otherwise making available without write-off a device, including a computer program, designed or adopted primarily for the purpose of committing any of the offenses under this act. A computer password, access code, or similar data by which the whole or any part of a computer system is capable of being accessed with intent that it be used for the purpose of committing any of the offenses under this act. This law now, the 10175, this provision criminalizes what? The production of sale, procurement for use, import, distribution, or otherwise making available of a device, including a computer program, designed or adapted primarily for the purpose of committing any cybercrime. Distribution now refers to the active act of forwarding data to others, while making available refers to the placing online devices, I may say, for the use of others. So the misuse of data, the law includes this for them or for the cyber criminals to be prohibited of certain use of devices such as computer programs. There are prohibitions. So what is the aim of this law? It is a procurement. For what? For them to import or distribute available devices in the market that is being used by the cyber criminals. So the misuse of devices is included in the number 1 of the categories of committing cybercrime. Lastly, in category 1, the so-called cyber squatting. Cyber squatting now is defined as the acquisition of a domain name over the internet in bad faith to profit, mislead, destroy reputation, and deprive others from registering the same if such domain name is, number 1, similar, I may say, identical, or confusingly similar to an existing trademark registered with appropriate government agency at the time of the domain. Number 2, identical or in any way similar with the same of a person other than the registrant in case of a personal name. And lastly, acquired without right or with intellectual property interest in it. So cyber squatting, basically, in simple words, gumagawa ka ng isang pekeng website na may kapangalan, just like gagawa ka ng Jollibee. Gagawa ka ngayon ng isa pang Jollibee na similar or identical dun sa website na ginagaya mo. What? For profit. For either getting money or to destroy reputation.
ginagawa itong cyber squatting minsan to gain money. So magpapanggap sila na yun yung website na dapat puntahan ng tao. That is ginagawa nila similarly to that website, identical to that website, to gain money or to destroy reputation. Ginagawa nila yung website na yon, yung fake website na yon, what? To destroy their reputation of a single person or a group of companies.
Number 1 in computer-related offenses is computer-related forgery. In here, the input, alteration, or deletion of any computer data without right resulting in inauthentic data with the intent that it be considered or acted upon for legal purposes as if it were authentic, regardless whether or not the data is directly readable and intelligible, or the act of knowingly using computer data which is therein for the purpose of perpetuating a fraudulent or dishonest design. Computer-related fraud. The unauthorized input, alteration, or deletion of computer data or program or interference in the functioning of a computer system, causing damage thereby with fraudulent intent, provided that if no damage has not yet been caused, the penalty imposable shall be 1 degree lower. Number 3. Computer-related identity theft. The intentional acquisition, use, misuse, transfer, possession, alteration, or deletion of identifying information belonging to another, whether natural or juridical without right, provided that if no damage has not yet been caused, the penalty imposable shall be 1 degree lower. One of the computer-related identity theft form is phishing. It is a form of identity theft which occurs when a scammer sends mass email posing as banks, credit card companies, or popular commercial websites asking receipt to confirm or update personal and financial information in a hyperlink to a lookalike coming from the original website. Number 3. Content-related offenses. Number 1 is the cybersex. The willful engagement, maintenance, control, or operation, directly or indirectly, of any lascivious exhibition of sexual organs or sexual activity with the aid of a computer system for favor or consideration. Next is the software privacy. Theft or software through the illegal copying of genuine programs and distribution of products intended to pass for the original. Retail revenue losses worldwide are ever increasing due to this crime can be done in various ways: end user, copying, hard disk loading, counterfeiting, illegal downloads from the internet. Pornography is the first consistently successful e-commerce product. The internet is being highly used by its abusers to reach and abuse children sexually worldwide. The internet is very fast becoming a household commodity in Philippines. Its explosion has made the children a viable victim to the cybercrime. As more homes have access to internet, more children would be using the internet and more will be victim of pedophiles. Anybody, including children, can log on to the internet and access websites with pornographic contents with a click of a mouse. Computers also aid in production, distribution, encryption, and storage of digital images of child sex. Email threat or extortion. The criminal sends threatening emails or comes in contact in that rooms with victim, copying the company's confidential data, trade secret, in order to extort huge amount of money to the company. Cyber-stalking or harassment. The criminal follows the victim by sending emails, entering the chat rooms frequently, a form of electronic harassment, often expressed or implied physical threats that creates fear in the victim. Any intentional or substantial and unreasonable intrusion into the private file of a person that causes the person to suffer mental distress. Cyber defamation. The making of false statement of fact that injures someone's reputation, the public nature of news groups, bulletin boards, and even email presents the opportunity to publish defamatory statements. Now, we know that cybercrime creates a big problem for us. That's why, as a nation, we should not taking it for granted. Now, we will learn what are the tools and measures that the Philippine government used to combat cybercrime. For an example, we do have the Republic Act 10175 or the Cybercrime Prevention Act of 2012. Let us now take a look what are the salient provisions of that act.
Republic Act 10175 or the Cybercrime Prevention Act of 2012. The state recognizes the vital role of information and communication industries such as content production, telecommunications, broadcasting, electronic commerce, and data processing in the nation's overall social and economic development. The state also recognizes the importance of providing an environment conducive to the development, acceleration, and rational application and exploitation of information and communications technology or the ICT to attain free, easy, and intelligible access to exchange and or delivery of information, and the need to protect and safeguard the integrity of computer and communication systems, networks, and databases, and the confidentiality, integrity, and availability of information and data stored therein from all forms of misuse, abuse, and illegal access by making punishable under the law such conduct or conducts. In this light, the state shall adopt sufficient powers to effectively prevent and combat such offenses by facilitating their detection, investigation, and prosecution in both the domestic and international levels and by providing arrangements for fast and reliable international cooperation.
The law penalizes crimes committed using a computer, even those under the revised penal code, whether the computer was a tool or instrumental to the commission of the offense. However, liability on other laws Section 7 was struck down by Supreme Court as it violated the provision in Double Jeopardy. This due to the fact that the law aims to impose a separate penalty for a crime committed using a computer, which is likewise penalized by the RPC. In terms of the jurisdiction, there are regional trial courts designated as special cybercrime courts shall have jurisdiction over any violation of the provisions of this act, including any violation committed by a Filipino national regardless of the place of commission. The responsibilities of the Philippine National Police and the National Bureau of Investigation in combating cybercrime. In 10175, it stated that the PNP and NBI are mandated to organize a cybercrime unit or a center manned by special investigators to exclusively handle cases involving violation of this act. The PNP and NBI are required to submit timely and regular reports, including pre-operation, post-operation, and investigation, results, and such other documents as may be required to the Department of Justice for review and monitoring. Note, getting a court warrant is a must in hunting down a suspect in cybercrime. Inadmissible evidences. Any evidence procured without a valid warrant or beyond the authority of the same shall be inadmissible for any proceeding before any court or tribunal. In the access limitation, the Supreme Court struck down Section 19 of the law that gives the Department of Justice powers to order the blocking of access to a site provided there is a prima facie evidence supporting it. Now, let us take a look what are the cybercrime authorities. Number 1, Office of the Cybercrime within the DOJ, designated as the central authority in all matters relating to international mutual assistance and extradition. Number 2, the CICC or the Cybercrime Investigation and Coordinating Center. It is an interagency body to be created under the administrative supervision of the Office of the President for policy coordination among concerned agencies and for the formulation and the enforcement of the National Cybersecurity Plan. Now, we learned some of the salient provision of the Act. Now, let us take a look upon what are the issues on cybercrime law. Number 1, the discrimination against online crime. In crimes committed online, the law gives higher penalty compared to its offline counterpart. This is seen as violation of principles within the e-commerce law, where both offline and online evidence is given equal weight. In its implementing rules and regulations, it also indicated not to give special benefit or penalty to electronic transactions just because it is committed online. However, the reason for this is also to increase the penalties. The original revised penal code, for example, gives penalty for libel in amount of up to 6,000 pesos. Another is the real-time data access. The need to access real-time data gives the law enforcement agencies an opportunity to monitor activities of cyber criminals. This can be used in tracking scammers and any critical incident as it happens, such as kidnapping and other in-progress crimes where immediate access is important. Another law in combating cybercrime is the E-Commerce Act or the Republic Act 8792. It is merged version of House Bill number 9971 and Senate Bill number 1902. It was signed into law on June 14, 2000. A month later on, July 14, 2000, the implementing rules and regulations or the IRR was digitally signed by Secretaries Manuel A. Roas II and Benjamin E. Jokno and Governor Rafael B. Buenaventura during the plenary session of the Global Information Infrastructure Commissions. The salient features of the acts are: it provides for the legal recognition of electronic documents or data messages. It provides for the legal recognition of electronic signatures. It provides for the legal recognition of electronic contracts. It mandates all government agencies to, among others, transact government business and perform government function using electronic data, messages, or electronic documents within 2 years from the date of the effectivity of the Act. It mandates the government to install an electronic network to known as RP Web within 2 years from the date of effectivity of the Act, and it penalizes the offenses of hacking and piracy. Trivia. The provision gained media attention before the act was signed into law because of the I Love You virus incident. It has been said that there is no crime when there is no law punishing it. During the commission of the crime of that love bug virus, the NBI couldn't file a case that will certainly punish that man because there is no law punishing or defining the criminal behavior or criminal act done by that certain Filipino hacker. That's why it pushes more for the government to create or to sign a law that will certainly punish or certainly define the different cyber criminal acts for it not to be dismissed and not to be an opportunity for the cyber hackers to do their illegal activity. There are several enforcement of anti-cybercrime laws. Number 1, as mentioned a while ago, Cybercrime Investigation and Coordinating Center or the CICC. They are the ones who are in charge for the formulation and enforcement of the National Cybersecurity Plan. Number 2 is the Anti-Transnational Crime Division or the ATCD of the CIDG of the Philippine National Police that detects cases of cybercrime and cybersecurity offenses. Number 3 is the Anti-Cybercrime Division of the National Bureau of Investigation, handles cases of cybercrimes filed before their office for investigation and resolution. It has been said that crime is dynamic. It varies, it changes every time. And cybercrime is one of the most serious crime as of today that requires an intelligent way of investigating. Now, we will learn how to handle and how to investigate cybercrime criminal activities. In handling electronic evidence at the crime scene, normally consists of the following steps. Number 1, recognition and identification of the evidence. Number 2, documentation of the crime scene. Number 3, collection and preservation of the evidence. Number 4, packaging and transportation of the evidence. And number 5, information in these documents assumes that A. The necessary legal authority to search for and seize the suspected evidence has been obtained. B. The crime scene has been secured and documented. C. Crime scene protective equipment is being used as necessary. To be more precise, these are the following steps in handling electronic crime scenes. Number 1, an investigator shall secure and evaluate the scene. Ensure that all persons are removed from the immediate area from which evidence is to be collected at this point in the investigation. Do not alter the condition of any electronic devices. Note, if it is off, leave it off. If it is on, then leave it on. Next step is to conduct preliminary interviews. Separate and identify all persons, witnesses, subjects, or others at the scene and record their location at time of entry. Consistent with departmental policy and applicable law, obtained from this individual information, such as owners and users of electronic devices found at the scene, as well as passwords, usernames, internet service providers, the purpose of the system, any unique security schemes or destructive devices, any offsite data storage, any documentation explaining the hardware or software installed on the system. Number 4, collection of computer evidences. An investigator must record in all notes, all actions, and take any changes that you observe in the monitor, computer, printer, or other peripherals that results from your actions. Observe the monitor and determine if it is on, off, or in sleep mode. Then decide which of the following situation applies and follow the steps for that situation. Regardless of the power state of the computer, on, off, or sleep mode, remove the power source cable from the computer. Take note, not from the wall outlet. If dealing now with laptop, in addition to removing the power cord, remove the battery pack. The battery is removed to prevent any power to the system. Number 5, packaging of electronic evidence. Ensure that the proper procedures are followed for packaging. Number 1, ensure that all collected electronic evidence is properly documented, labeled, and inventoried before packaging. Pay special attention to latent or trace evidence and take actions to preserve it. Pack magnetic media in antistatic packaging, paper or antistatic plastic bags. Avoid using materials that can produce static electricity, such as standard plastic bags. Avoid folding, bending, or scratching computer media such as diskettes, CD-ROMs, and tapes. And lastly, ensure all the containers used to hold evidence are properly labeled. Note, if multiple computer systems are collected, label each system so that it can be reassembled as found. Like example, System A mouse, keyboard monitor, main base unit, and etc. Smartisan Procedure. Keep electronic evidence away from the magnetic sources, radio transmitters, speakers, and etc. Avoid storing electronic evidence in vehicles for a prolonged period of time. Conditions of excessive heat, cold, or humidity can damage electronic evidence. Letter C. Ensure that computers and other components that are not packaged in containers are secured in the vehicle to avoid shock and excessive vibrations. And lastly, maintain the chain of custody on all evidence transported. And lastly, number 7, storage procedure. Ensure that evidence is inventoried in accordance with departmental policies. And B, store evidence in a secure area away from temperature and humidity extremes. Protect it from magnetic sources, moisture, dust, and other harmful particles. Note, be aware that potential evidence such as dates, times, and system configurations may be lost as a result of prolonged storage. They said that prevention is always better than cure. That's why, let us take a look what are the precautions or the things that we need to do for us to prevent cybercrime activities. Number 1, to prevent cyberstalking, avoid disclosing any information pertaining to oneself. Number 2, Always avoid sending any photograph online, particularly to strangers and chat friends, as there have been incidents of misuse of the photographs. Number 3, always use latest and update antivirus software or guard against virus attacks. Number 4, always keep backup volume so that one may not suffer data loss in case of virus contamination. Number 5, never send your credit card number to any site that is not secured to guard against frauds. Number 6, always keep a watch on the site that your children are accessing to prevent any kind of harassment or deprivation of children. Number 7, it is better to use security program that gives control over the cookies and send information back to the site, as leaving the cookies unguarded might prove fatal. Number 8, website owners should watch traffic and check any irregularity on the site. Putting host-based intrusion detection devices on servers may do this. And number 9, use of firewalls may be beneficial. And lastly, web servers running public sites must be physically separate, protected from internal corporate network. Credit card fraud. Credit card fraud is a wide-ranging term for theft and fraud committed using an access device or any similar payment mechanism as a fraudulent source of funds in a transaction. The purpose may be to obtain goods without paying or to obtain unauthorized funds from an account. Credit card fraud is also an adjunct to identity theft. Methods of fraud. The methods of fraud and types of fraud are increasing as criminals learn new techniques and get improved technology. The most common methods of fraud today include copying and cloning of cards, B. ATM fraud, C. Internet card fraud, and lastly, PIN number stealing. One of the most of credit card fraud is the so-called skimming, in which a handheld device called skimmer is used to capture the information contained therein. The data can be transferred onto a computer system later. The information like name, credit card number, expiry date, and etc. can be used. Another law is the Republic Act 8484, or the Access Device Act, is an act regulating the issuance and use of access devices and prohibiting the fraudulent acts committed relative thereto, among others. By enacting this legislation, the state recognizes the recent advances in technology and the widespread use of access devices in commercial transactions. Access device is any card, plate, code, account, number, electronic serial number, personal identification number, or other telecommunication service, equipment, or instrumental identifier or other means of account access that can be used to obtain money, goods, services, or any other thing of value or to initiate a transfer of funds. It includes credit card. Let us now move on to electronic documents. An electronic document is admissible in evidence if it complies with the rules on admissibility prescribed by the rules of court and related laws and is authenticated in the manner prescribed by these rules. In the best evidence rule, an electronic document shall be regarded as the equivalent of an original document under the best evidence rule if it is not printout or output readable by sight or other means shown to reflect the data accurately. Now, we can say that the electronic documents has a weight as an evidence. Why? Because of its reliability, integrity as an information, its nature and quality of information, and it gives specific data about the crime itself. One of the growing issue that is in relation with the cybercrime is the copyright issue. That's why the Philippine government made a law that aims to protect the trademark, the patent, and the copyright of the real owner. That is the Republic Act 8293, or the Intellectual Property Code of the Philippines. Now, let's take a look what is the difference between a copyright and a patent. A patent is a statutory grant by the government which confers to an inventor or his legal successor in return to the disclosure of the invention to the public.
the right for a limited period of time to exclude others from making, using, selling, or importing the invention within the territory of the country that grants the patent. While a copyright is maybe vested in a work closely similar or even identical to an earlier patented work, provided that the former work is original, owes its existence to the original author. In speaking about the duration of a copyright, literally artistic works and derivative works of a single creator is composed of a lifetime creator and 50 years after his death. If it is a joint creation, lifetime of last surviving joint creator and 50 years after his death. Anonymous or pseudonymous work 50 years after the date of its first publication, except where the author's identity is revealed or no longer in doubt before the expiration of said period of the rules on single creator, joint creation shall apply. Work of applied art, 25 years of date of making. Photographic and audiovisual works, 50 years from publication of the work, and if the unpublished, 50 years from the making. Newspaper article, lifetime of the author, and 50 years thereafter. The subjects of copyright are divided into two. Number 1 is the original works. This includes books, pamphlets, articles, and other writings, periodicals and newspaper, lectures, sermons, addresses, dissertation prepared for oral delivery, and etc. While the number 2 is the derivative works. These are the dramatizations, translations, adaptations, abridgments, arrangements, and other alterations of literary or artistic works and collections of literary, scholarly, or artistic works and compilations of data and other materials which are original by reason of the selection or coordination or arrangement of their contents. These are now the things that a copyright doesn't protect. Number 1, no idea, procedure, system, method, or operation. Number 2, news of the day. Number 3, any official text of a legislative, administrative, or legal nature. Number 4, any work of the government of the Philippines. Number 5, pleadings. And number 6, decisions of courts and tribunals. In copyrights, there are two independent rights. First is the copy or economic rights, and number 2, the moral rights. In copy or economic rights, it consists the reproduction of the work or substantial portion of the work, dramatization, translation, adaptation, abridgment, arrangement, or other transformation of the work. First, public distribution of original and each copy of the work by sale or other forms of transfer of ownership. Rental of the original or a copy of an audiovisual, I may say, or cinematographic work. Public display of the original or a copy of the work. Public performance of the work and other communication to the public of the work. And with the moral rights, it requires that the authorship of the book's works to be attributed to him, to make any alteration of his work prior to or withhold it from publication, to restrain the use of his name with respect to any work not of his own creation. The moral rights aforementioned may be waived by a written instrument. To object to any distortion, mutilation, or other modification of other derogatory action in relation to of his work. Now, who is the author of a copyright? Number 1, a single creator. Copyrights belongs to the author of the work. Number 2, the joint creation, or the copyrights belong to the authors jointly as co-owners. Number 3, employees' creation. Copyrights belong to the employees. Number 4, commissioned work. Work belongs to the person commissioning, but the copyright remains with the creator. Number 5, cinematographic work. Producer has a right for purposes of exhibition. Number 6, anonymous and pseudonymous works. Publishers shall be deemed representative of the author unless contrary appears. Author discloses his identity. And collective works, the contributor is deemed to have waived the rights unless he expressly deserves it. What is now a fair use of a copyrighted work? It is a privilege now enjoyed by a person
other than the owner of the copyright, to use the copyrighted material in a reasonable manner without the owner's consent, notwithstanding monopoly granted to the owner of the copyright. Factors to be considered in determining fair use. Purpose and character of the use. Next, the amount and sustainability of the portion used in relation to the copyrighted work as a whole, the nature of the copyrighted work, and the effects of the use upon the potential market or the value of the copyrighted work. Talking about personal use and private use, personal use is the making of a single reproduction, adaptation, arrangement, or other transformation of another's work exclusively for one's own individual use in such cases as personal research, learning, or amusement. While private use is the reproduction, adaptation, or other transformation for it in a single person, as in the case of personal use but also for a common purpose by a specific circle of persons only. Importation of copy of a work by an individual for personal use or personal purposes is allowed if the copies of the work is not available in the Philippines and not a copy at a time is imported for strict individual use, or the use of importation is by authority and for the use of Philippine government. Not more than 3 copies may be imported by religious, charitable, or educational societies or institutions provided they are not for sale. Copies from part of libraries and personal baggage belonging to persons or families arriving from foreign countries and are not intended for sale. What are the remedies of the owner of the copyright against infringers? The infringers are exposed to both civil and criminal liabilities. In the civil action, an injunction may be prayed for to the prevent of infringement. Actual damages may be awarded by the court on the basis of proof presented by plaintiff of sales made of the infringement work, minus cost, which defendant can prove. Damages may also include the award of moral and exemplary damages in the discretion of the court.